Hi. So we had this incredible ramp up in excitement up to the 25th of May with a number of UK organizations deciding that GDPR compliant was something they really needed to do. As I said just before lunch, something like 25%, maybe 30% of UK organizations claim to have done something. We saw a real spike through May of people buying privacy notices. Templates, single standalone privacy notices off our website. We sold hundreds and hundreds of them to organizations who quite clearly thought getting a privacy notice template would do the job for them. They would therefore be compliant. We've spoken to quite a lot of them since, and many of them are saying, yes, we haven't quite got round to customizing it yet, but we plan to in a little while. And that's been a bit like most of the feedback from the market. The excitement of getting GDPR ready has shifted to the, thank heavens, May the 25th passed and nobody came round and inspected us and found that we were wanting and we didn't get a fine, and there haven't been any huge fines since then. And so quite a significant drop-off in organizations seeing GDPR as something that they should be doing. However, at the same time, there was a significant increase in data breach notifications to the GDPR and in complaints to the ICO rather. And the most significant really is the increase in complaints, because data subjects suddenly discovering they've got rights is going to be one of the drivers of future GDPR uptake. As organizations realize that if you have a breach and you pretend it didn't happen because that way you don't get fined, the people whose data got exposed may just go and complain. And when the ICO says, gosh, I've had 5 people complain about this data breach, but I haven't got a data breach reported, they then go and do an investigation, and you're already in trouble because there's a specific fine reserved for not reporting data breaches. So when you have a look around the UK in terms of data breaches, a year ago we had 540 breaches in the private sector. That's 25th of May to 25th of August, so doing some comparative period analysis. We had 216 in the private sector. The situation in the UK was that while there was no legal obligation to report breaches, the government expected public sector organizations to report breaches to the ICO, and 33 from the third sector. In the comparative period, what was about 750 breaches increased to something in the order of 4,500 breaches this year. So the change in regulation made a significant difference in the number of people reporting. The public sector, which in theory was already reporting, clearly wasn't, because the number of breaches reported went from 540 to just over 2,000. Very significant proportion of that in the education and health sectors, quite a lot in local government. Local government has a well-established tendency not to do anything that's secure. And the private sector is where the biggest shift has been. Private sector, which if you'd looked at the stats a year ago, you would have said, hey, they don't get breached much, their security must be good. Not the case at all. They just didn't have to report breaches. So number of breaches gone up very significantly, also very significantly in the third sector. So we offer a data protection officer as a service. We've got a growing number of clients for whom we do their data protection officer work. And that means that we're able to identify trends amongst clients and identify what's common. And we've seen that of the breaches that occur, round about a third of them are actually reportable. So what GDPR requires is that if the breach is going to have an impact on the rights and freedoms of data subjects, then it's got to be reported to the ICO. If there's just a breach as a controller, you're supposed to document it and learn from it, but you don't have to report it to the ICO. About a third of all breaches are notifiable. A small percentage of those, from our experience, is where the customer has said, we'd like you to report it anyway. We know it's not something that has to be reported, but we just feel more comfortable if we told the ICO. And for what the ICO says, there's quite a lot of organizations reporting breaches to that extent, something like maybe 10% of the whole. So if you look at the 25th of May to 25th of August, probably out of 4,500, the real number of breaches is round about 4,000. That's going to go on happening. As more and more organizations get to grips with what compliance means, there will be a growing number of breach breaches reported. And this is data which is useful when talking to your clients about whether or not they should worry about being either GDPR compliant or have a privacy program or should be secure. Because the reality is most companies are not. And being able to say to clients, this is just the shift because of organizations being forced to report, you don't know whether or not you're going to suddenly wake up one morning and discover you've had a breach as a result of which you become one of those statistics. And the fact is you can't fix your inadequate compliance after you've been breached. You're done. You're back in that, what could I have done to avoid this breach happening question when you're reporting the breach. So these statistics are useful in terms of talking to your clients. The most common causes of breaches are phishing attacks, unauthorized access to data, ranging from no passwords to people being able to take advantage of privileges. Malware is the third, and ransomware is the fourth most common form of attack. You see how these are all primarily social engineering type attacks. They're the things that require your clients to be thinking about staff awareness, about policy, about enforcement, about training, all of those parts of how to do their job properly, how to manage the organization properly. The ICO so far has issued, she's never before this year issued the maximum fine allowable under the Data Protection Act 1998, or the act which allowed her then to add fines. And this year she's issued two of them, Facebook and Equifax, both got maximum fines. And we think that the message in that is quite clearly that much as she's been saying we're not going to carry a big stick and beat people up, she's saying we are actually. Fines are not going to start off at a couple of £10,000. She's sent a very clear signal, we believe, that fines are likely to be serious. The law says fines should have an impact. They're meant to be deterrent. So again, an important thing to be saying to clients who go, well, if it's a fine, it won't be that serious. First time in her life, £500,000 fines, the maximum possible fine under the Data Protection Act 1998. I talked about PCI, about Superdrug, and about Facebook earlier on. But the key points I want to make, because I think these are things that are going to affect more and more clients, looking particularly at British Airways, a large organization which you would have thought would be compliant, but as we understand it, decided they needed to save money over the course of the last year or 18 months in terms of their IT back office operations. Had a PCI breach. That's a de facto privacy breach. It on its own requires you to have to report. So you've got two regulatory problems in one. You've got a forensic investigation, you've got an ICO investigation, you're going to be offering compensation because, hey, if you have 500,000 people whose known holiday dates are publicly available, how much risk are their home addresses at? Forget any other data which got released, but suddenly you're a criminal and you can find out with their home address 500,000 people who will be away and when they'll be away. That just makes breaking in so much simpler. It just reduces the risk that you've got to deal with. The biggest challenge that you've got, not customers, loss of customers, not just diversion of management, but is class action suits. And Morrison's is the straw that points at the way the wind's going to blow. GDPR specifically allows individuals to put together class action suits, to come along and say, we as a group feel we've been damaged by this breach. 500,000 people in British Airways, there are two organizations busy putting together class action suits for those folk. The suggestion is that everybody who's been affected has probably suffered damages which are worth £1,500 each. GDPR specifically allows you to get financial compensation for non-financial damage. So the argument is the inconvenience, the having to get a new credit card, the finding yourself away on holiday and now your credit card has to get cancelled, the sheer distress of discovering your data's on the internet, all of that's probably worth £1,500 a piece, times 500,000 people. Is a lot of money. That's way more money than simply the cost of dealing with the breach. It's way more money than anything else other than perhaps the fine on its own. And it's that, the vicarious liability I talked about earlier on, the class action suits coming out of this, more and more organizations in thinking about security are going to have to think beyond the simple thing that happens. And class action suits are likely to be focused on large organizations, but they could also be focused on small organizations. It depends on the value of the data and whether or not there's a legal firm who can see some sense in helping those poor, struggling folk put together an approach. And you have to ask yourself what all of those companies who specialize in getting your PII compensation are going to do when that window closes. I don't know, are there law firms who might want to find a simple way of making money? So we've talked about the vicarious liability. The key point, the thing which should be part of most of your conversation with the clients when they're worrying about do we do this or not, is the right of the damaged data subject to receive compensation from the controller or the processor for the damage suffered. The first GDPR enforcement notice has already been issued. It was issued by the ICA on the 24th of October to aggregate IQ data services who were tied into the whole Facebook scandal. And the European Data Protection Supervisor, the guy who is in charge of how GDPR is enforced across the whole of the European Union, has said the first fines will be issued by the end of this year. Hasn't said who will be fined or how much, but said the first fines will be issued across the European Union in a reasonably coordinated way towards the end of this year. So we see lots of organizations who are saying, don't have to worry too much, let's do terribly much right now. And then suddenly the fines are going to start hitting, and some organization begin to say, actually, maybe now's the time to do something. So it's worthwhile just making sure that you're ready and your clients are ready. More interestingly, one of the pieces of legislation which ties in with GDPR is the Privacy and Electronic Communication Regulation. And PECR, which in the UK is still an existing regulation, is going through an update process. The e-privacy regulation will be out sometime. We don't know when. It's designed to align with GDPR. But much more interestingly, a couple of days ago, an update to the PECR passed through Parliament. And it said that directors of companies, where those companies have also been fined, either through negligence or deliberately, for sending out unauthorized spam emails, the directors can also be fined up to £500,000 apiece. There's nothing in that specific regulation which restricts it only to those companies which are sending out large volumes of spam email. It says very specifically the directors of companies which have been fined for sending out emails which have not been authorized, they too can be fined. And that comes into effect in a month's time. So we've suddenly shifted. This is not GDPR, it's PECR, so it relates only to the lawful basis on which you are communicating with customers. So this is about understanding properly the law. It's understanding legitimate interest. It's understanding whether or not you need consent. It's understanding soft opt-in under the current PECR regime. But it's understanding that if the organization is fined for being in breach of PECR, the directors too can individually be fined up to £500,000 each. It's the first time we've had a meaningful addition to UK legislation which focuses on the liability of individual directors. And it was the liability of individual directors under the health and safety legislation which shifted the behavior of organizations around health and safety so substantially away from we'll just make it the employee's job to suddenly it became the director's job. Directors have a bit of antipathy to finding themselves on the hook for £500,000. That's potentially a significant game changer. It's worth, again, beginning to talk to clients about how you've addressed the legal aspects of this. And as a partner of ours, of course, through our law company, GRCI Law, you can deploy very specific, focused law services to help clients deal with that very specific issue. Then we have probably Brexit. No idea of whether it's going to happen or not, no idea if it does happen, what it will look like, haven't got a clue. I kind of had an idea 2 years ago that it would happen, would be a disaster. Now I haven't got a clue. It's just very, very opaque. But as we know, GDPR is already part of UK law, so it will survive whatever form Brexit takes. The Data Protection Act 2018 is established UK law. The challenge for UK companies is that at the point where UK leaves the European Union, and it's not yet clear to me whether if Brexit goes ahead as Mrs May intends and we officially leave at the end of March next year, we will also have left from the perspective of the GDPR. Because if we have left, which on the face of it we probably would have, we'll be a third country. And that means every organization providing services into the European Union after the end of March next year will need to have a representative inside the European Union after March next year. It's one of the many things which those who are really keen on Brexit, who think it's going to be the easiest thing in the world, haven't thought about. There are about 255,000 businesses in the UK which provide products and services into the European Union as the core of their business. If you have those kind of clients, now is the time to be thinking about what might happen. I don't know what will happen. There is no clarity. There is no guidance that means anything other than we will need to have some kind of mechanism that enables us also to be an approved country, to have an adequate regime. Part of the logic for adopting GDPR as a DPA 2018 is in the hope that the European Union will rule that the UK has an adequate data protection regime so that it's legal for EU companies to export data to the European Union. But that hasn't happened yet. There is no ruling that says the UK has an adequate data protection regime because we're still in the European Union. If you're relying on the fact that the Information Commissioner can be the lead supervisory authority for an organisation which is dealing in the UK and across the European Union, that's legally not going to apply after the 29th of March. Because GDPR is very clear that a lead supervisory authority has to be the lead supervisory authority of a member state of the European Union. There are some significant implications, therefore, for any of your clients who are dealing from the UK into the European Union or moving data between the UK and the European Union arising out of Brexit, however Brexit turns out. The only thing that means those problems go away is if Brexit comes off the agenda. It may be that the transitional period means that we can all go on pretending that we're part of the European Union and therefore none of these changes will come into place. We do not know. Important things to be aware of because they're going to affect some of your clients. So I've touched on the whole business of the UK Data Protection Directive, the interaction with the PECR, the upcoming privacy regulation. The e-privacy regulation will almost certainly come into force during the period that we are going through a transition. So this is the other side of the story. We are apparently going to be bound to apply European Union regulation during the transition period. So if e-privacy comes in, it's entirely possible we'll have to apply it at the same time as being outside the EU and therefore having to have a representative and all of those kind of things. None of this is clear. There's obviously no body with a proper understanding of privacy sitting in with the folk who run the anti-Brexit campaigning or even the Brexit agreement campaigning work. We talked about the NIS directive. It's got some significant fines attached to it, but the enforcement mechanisms are not nearly as dramatic as for GDPR. So we expect that to be a slow-running, slow-growing area. The impact on most organizations will come not just because they are operators of essential services or digital service providers, but because they're providing services into those sectors. So as organizations deal with the need to extend cybersecurity across their supply chain, it will begin to affect suppliers of utilities, suppliers of the health service, suppliers of digital service providers. So we expect to see that beginning to percolate through. If you have clients in the health sector, of course, the Data Security and Protection Toolkit, the DSP toolkit, has been brought into line with the GDPR requirements, and the requirement is for completing the new DSP toolkit by the 31st of March 2019, although larger organizations should already have completed their submissions. Again, the enforcement regime is not as obvious as is that for GDPR, but it's nevertheless, for any organizations operating in the health service, a significant area of compliance. The DSP toolkit is meant to be a step forward from the IG toolkit. It's meant to bring a much more appropriate level of security across the 10 data security standards from the National Data Guardian than under the IG toolkit. But it's too going to shape how the health sector, and that's a very broad sector, goes about meeting cybersecurity requirements. And then a couple of other areas where ongoing regulation. And regulation, as we see it, is going to be more and more a driver of cybersecurity. The financial sector is much more frightened, I think, where personal data is concerned, about the Financial Conduct Authority than about the ICO. The Financial Conduct Authority has got much greater powers around levying fines than potentially the ICO has. The operational resilience legislation is very clear. There's currently a joint discussion paper which, as tends to happen in the financial sector, will be discussed and then suddenly become the requirement almost overnight, which says that banking and financial market infrastructures have to focus on making sure that if operational disruptions occur, the dependencies that are there have been dealt with to the greatest extent possible. That comes down to, in most instances, have you got a CISO? Have you got a proper have you got a proper cybersecurity infrastructure? Have you dealt with the broad range of things that are necessary for you to be compliant around personal data, around cybersecurity, and around business continuity? So the same kind of requirements, very specifically in the financial sector, as we are going to be seeing in the utilities and critical national infrastructure. In the gambling sector, of course, where the Gambling Commission regulates gambling, there's long been a set of requirements around cybersecurity, because it's okay to lose a lot of money on a gambling website, but it's not okay to get ripped off by a cyber criminal. And so you have to demonstrate that you're appropriately secure. You've effectively got to have compliance to ISO 27001 and an independent audit of compliance with ISO 27001 as the cornerstone of your Gambling Commission compliance. If you're unable to do that, you have your Gambling Commission license taken away. So quite a lot of changing regulations, or more emphasis being given to existing regulation, in addition to which is the ongoing challenge that the European Union has with the United States. And again, in the whole Brexit issue, one of the unconsidered issues is that the GDPR, or the Data Protection Act 2018, doesn't deal with the safe harbor provisions outside of the European Union. So under the GDPR, as a member of the European Union, if the EU has identified New Zealand as an adequate data protection regime, or says that the EU-US Privacy Shield gives the appropriate level of adequacy, when Britain leaves the European Union, that stuff falls away. So from a Data Protection Act point of view, we don't have, as the UK, any identified countries to which it is going to be legal to export data, because we don't have an adequacy regime, and there's been nothing which has said we will therefore adopt whatever the European Union has said. If the EU-US Privacy Shield is found wanting, and there are a significant number of people in the European Union who think that President Trump is not entirely reliable where personal data is concerned, and the Privacy Shield as a result is found to be inadequate and declared illegal, we've got an even bigger problem than we'll have when we leave the European Union, because there won't be a Privacy Shield. The Privacy Shield is the EU-US Privacy Shield, not the UK-US Privacy Shield. So all of the organizations in the UK that currently export data to the US, or deal with customers, or have offices in the US, the moment we leave the EU, we potentially have a huge problem in the US, because there's no Privacy Shield in place. Even if we found a way of adopting it, and we're dealing with customers in the EU and it collapses, then we've got a different problem, because our EU business is going to have no real effective mechanism of dealing with the US. So it's quite an exciting environment, really. If you're dealing with data, if you're dealing with organizations who are dealing with data, it's a complex and changing environment. As I said, regulation is going to increasingly drive what people have to do. And I think our next session will give you a chance to talk to some of our consultancy and privacy people about how these issues might get addressed. We set up a law company inside the group very specifically because we begun to recognize that being able to go and speak to a law firm, and I don't know about your law firms, but mostly our experience of law firms is that any call involves about 5 members of the practice, and they speak quite slowly because they want to make sure you properly understand the complex thing there, and that takes you about 4 days to send you a letter before they can give you any advice, because they've got to do some proper know your customer stuff. So we set up an unregulated law firm outside the SRA where we can provide fixed prices, do work very, very quickly, do it to a pattern. So having standard contract clauses shouldn't be something that requires 6 months worth of work. You should be able to get standard contract clauses in place in 6 or 8 hours, really. So you should be able to deploy, therefore, to your clients services from the GRCI law company. Anyway, that's the changing environment. That's what we see happening. Any questions anybody would like to ask? Is that all that clear? Thanks very much.